So, for some strange reason, I woke up bright-eyed and bushy-tailed at 6:15 this morning, which was rude. But that means that I read the filings that happened in the Lively case last night, and so I'm going to tell you just sort of the overview of what got filed. So first, if you hear a noise, I'm letting Frank eat the end of a container I was eating food out of. I usually let him lick it, and he's doing it, and it's very loud. Okay, so first is that Wayfair responded to the motion to compel about the internal investigation. I thought they did a very nice job, especially considering the bombastic nature of the motion to compel and all of the communications that went along with it. They did a very nice job in their response of it being just very sober and very straightforward, and they didn't point fingers at anyone, and they just said, we cannot turn over these materials because we do not have custody of them. The investigation is ongoing, and the investigative firm has custody of them. So there's nothing to compel from us. We don't have it. They said they took no position on, whether the third party did or didn't turn them over. They're going to let the third party fight their own battle in that particular way. But they did sort of say, even if somehow, you were able to get them to respond to you, they have a work product problem because, they're a law firm, an investigative law firm, and Wayfair asked them to do this work. So I thought they did it in a different way than I expected. But they did sort of in substance what I expected, which is this is not as big of a deal as they're making it. And this is also not a right now problem. We're doing an investigation. We have to do an investigation because it's our position that we didn't know about any of this until she filed this complaint. And so, yelling at us about it really doesn't help anything. I thought they did a very nice job. Again, it was very sober. It was very calm. It was just sort of no, we don't need to deal with this now. And we don't even have it. So there's no need for this. And it gives the judge an opportunity to kick the can down the road and say, no, we're not going to interrupt an investigation for this. If we want to talk about this later, we'll talk about it later. The other thing that was filed is a new motion to compel. Remember, guys, we asked for discovery disputes. This is what we wanted, so we know what was going on, and we're getting it. Is another motion to compel, this time from Leslie Sloan's lawyers. And they are asking the court to compel documents in response to a request for production to the Daily Mail reporter that is sort of central to the case against Leslie Sloan. So this is James Vituska, I think is his name. I don't want to butcher his name, but this is the guy. So the basis for the defamation claim against Leslie Sloan, and I agree with her, it is a little bit removed, right? What we have is a text message from Vituska saying Leslie Sloan told me that Blake was sexually assaulted, right? So the Wayfair parties have taken that and said, well, if James said that Leslie told him this, that means that Leslie said Blake was sexually assaulted, and that is defamation. But because it went through this other party, and because the party it went through is a reporter, it makes it difficult for the information to come out and get discovered. Now, they attach his responses. There's a couple things to note. One is he must be a freelance reporter because the request for production was sent to, and his responses are sent on behalf of him as an individual person. They did not go to the Daily Mail organization. They went to him as a human being, James Vituska. So he must be a freelance reporter because they are seeking this stuff from him as an individual. So that's number one. He does not look like he has the cover of the Daily Mail or any of the companies that own that publication. The second thing is that they put in a footnote that part of the reason why they're bringing this up now and having trouble getting this discovery is because this guy is set for deposition on June the 4th. And they are worried that they're going to get to the deposition and he's going to make the same objections that he made with regard to the documents, and they're not going to be able to depose him. So the primary defense for him, the primary objection to the request for production is the First Amendment. It's reporter's privilege. I don't have to turn over conversations that I had with sources. And, that's sort of typical of what a journalist would say. Now, there are a few instances, if you read the objections all the way through, where he will say, and this is typical, like, here's all the things, and I reserve all my rights to argue against the U.S. Constitution and all of these other laws about journalistic privilege. And then he'll say at the end, but subject to those objections, I don't have anything. Like, I don't have telephone recordings of my conversations with Leslie Sloan. So he does indicate in a couple of places where he doesn't have anything. But his primary argument is, this stuff is covered by the journalism privilege. I'm a reporter, and this was my source. But then the Sloan people kind of say, like, this is not your usual journalism and source question for a lot of reasons. And so the privilege either doesn't apply at all, or if it does, the sort of exception to the privileges should apply here. And the argument is, the main arguments are, it's been put in the amended complaint by Wayfair, so it's not privileged. We've all seen it. It's been put in issue in the litigation, so how can it possibly be privileged of how that came to be? How can we possibly defend ourselves in response to a claim of defamation if you won't tell us what that conversation was, and you won't tell us what information you have about that conversation? And I kind of get where they're coming from there. I think it's a fair point of, like, how does Leslie Sloan defend herself against a defamation claim that is based entirely on her conversation with a reporter and what he told third parties about that conversation if she can't discover anything about the conversations? So I hear what she's saying there. On the other hand, the reporter privilege is like a huge, very important concept, particularly in a New York court. Because so many news organizations are based in New York City, almost all of the big ones, the legacy ones at least, are, there's lots and lots of law in the Southern District of New York about the reporter-journalist privilege, and they have a big statute in New York that's pretty hefty on the side of reporters. So it is something, legally speaking, that's pretty difficult to overcome. And one of Vituska's main arguments that he makes in his objections is, and this actually seems fair to me, because I do think Leslie Sloan is like, how am I supposed to defend myself? He says, you don't have to get it from me, get it from them. If what you're concerned about is my communication with you, and then when I told Melissa Nathan about that conversation, go ask Melissa Nathan for the information. You don't need to get it from me. So that's sort of the out that he's trying to create for himself. But it looks like they need to resolve this before this guy testifies in a deposition on June 4th, or he may walk in on June 4th and say, I refuse to answer any questions after my name because I'm asserting the journalist privilege under New York law and the First Amendment to the Constitution. And I just have to give a shout out to Sloan's lawyers, because they do cite a case for the proposition of, just because you're gathering information as a journalist, if you don't actually intend to report on it, you can't use the journalist privilege. And the case that they cite for that is Von Bulow versus Von Bulow. And if you don't know what that is, go watch Reversal of Fortune. It's one of the best movies ever. It's Jeremy Irons and Glenn Close. It's a real story about rich people and all the crazy shit that they do. So I really liked that shout out, because that's exactly what happened in that case. Is you can't utilize the journalist privilege if you're just saying, well, go gather it because I'm a journalist, but I'm not going to report on it. Like, you have to actually have some intent to potentially report on it. And they say no one ever did. So this privilege shouldn't apply. So that's what's happening today. We'll see what responses come in later.